Hi everyone, so I often get asked, can a trustee claim the family home after a divorce? One of the most worrying questions people ask is this. If someone transfers their share of the family home during a divorce and later becomes bankrupt, can the trustee come after that property? The answer is yes, sometimes. When someone becomes bankrupt, a trustee is appointed to identify the assets that belong to the person who's bankrupt and make those assets available for his or her creditors. Part of that role involves reviewing transactions that took place before the bankruptcy. This includes property transfers as one of the assets. Imagine if a couple divorcing and one spouse transfers their share of the family home to the other. This may feel like a fair arrangement, particularly if there's children at home. But if the person who transferred the property later becomes bankrupt, then the trustee may review that whole transaction. The trustee will ask an important question: did the bankrupt person receive fair value for the share that they gave up? The answer is no. The trustee may apply to the court to review that transfer because it may have reduced the assets available to the creditors in the bankruptcy. And in some situations, the court may order compensation to be paid to the bankruptcy estate. That does not necessarily mean the home will be taken back, but the value transferred can be addressed. The family home is often the most valuable asset people own, which is why trustees examine these transactions ever so carefully. If you want to understand how insolvency law may affect property transfers and divorce settlements, visit navigatebr.com and book a meeting with me to better understand your options.